Welcome. Today we will discuss about unit number 4, arbitration, conciliation and alternative dispute resolution system, is ADR. What is arbitration? Main outlines of topics: introduction, arbitration and non-arbitational dispute, duties of arbitrator, benefits of arbitrator, means drawbacks, uh, kinds of arbitrations. Okay. Main focus, what is arbitration? आर्बिट्रेशन म्हणजे काय तुम्ही ऐकला तुम्हाला डेमो व्हिडिओ पण दाखवते मी. आर्बिट्रेशन म्हणजे काय? Arbitration is the process which is a dispute is submitted, means to an impartial outsider who makes a decision which is binding on both parties. Okay, means the process of resolving disputes between people or groups by referring them to a third party, means either agreed upon by them and provided by law who makes a decision. Okay. Means arbitration is the private determination of disputes, means by independent third party. Okay. Means an arbitrate hearing may involve the use of individual arbitrator or tribunal. Okay. This is a simple definition of arbitration. Any basic part for arbitration, means arbitrator enforces his own point of view, means on contending parties and the opinions of the participant are not giving any predominance. Means arbitration is a judicial process, means awards of arbitrator is binding and this on equity, means justice, that is there is no scope of the compromise. Okay. Means no more or less litigation, means their parties and apply where the place of arbitration in India, means it shall not affect any other law for time being, means any force in India, means in scope of arbitration. Okay. Mainly part for arbitration is the one of the technical alternative dispute resolutions, resolution means resolve dispute without using court resource, that is out of court settlement. Okay, means through there is no university defined definition of arbitration. Means however the any England and Husry law is the arbitration. Is the one party is the resolve, means any dispute in arbitration dispute is resolved with rather than national court of law and without justice, but the agreement of the parties to exclude it. Main process of arbitration. First arbitration process, means first case failed, then arbitration selection process, then preliminary hearing and scheduling order, and then discovery process, then hearing mediation, arbitration hearing, and post arbitration brief, and the final arbitration. This is the main arbitration process. Then arbitration dispute is the first properties. Sorry. Arbitral disputes is the property, insurance, contract, means including employment contracts and business partnership. Okay. I mean business partner dispute, family dispute, means matters and construction and commercial dispute is the main arbitral dispute. And non-arbitral मध्ये काय येतात? First, matters of criminal nature, means disputes relating to matrimonial relations, means testamentary matters relating to the validity of will, means relating of trust for public purpose of character of religion nature, means many matters relating to the gratuity of minor or any expiration process, means any um, Alternate dispute resolution ADR is the mechanism used across the world. It's effective, faster, and less expensive. Okay. Main non-arbitrary is the main universal matters in purpose of chargeable and religion nature. Okay. Then next, duties of arbitration. First, to do administrative oaths means parties and witness appearing to act judges see means impartially to put necessary to any party and dispute to determine the whom the cost of refers means award shall be paid and to award interest and fix amount, mode and time of payment. This is the main duties of arbitration. Main arbitration act two part. Arbitration Act 1940 and Arbitration Act 1960. Okay. Main use of arbitration in the form of alternate dispute solution means ADR is the resolve disputes outside the judiciary courts means dispute will be the decided by one or more person. Okay, means which render the arbitration award and arbitration decision or award legally binding on both side of enforceable in the courts. Okay, this is the main arbitration. First is the holding. The part is the holding hearing, issued decision and granted award, and determine the facts and applied rules of law. Okay. Main then advantages of arbitration. First, choice of decision makers with expertise. Then second, speed. Third, lower cost. Fourth, feasible. Fifth, confidentially. Sixth, less formal than court. Then seventh, preservation of business relationship. Okay. Main advantages of arbitration. Then disadvantages of arbitration. First, limited resource. Uneven player field means lack of transparency. Cost parties pay for arbitrator and agency means limited rights of Apple in favor means to the challenge and award. Then lack of formal discovery. Okay. Then main types of arbitration. Two types of arbitration: voluntary arbitration and compulsory arbitration. Okay. Voluntary arbitration is the implies that two continually parties unable to compose their difference by themselves means agree to submit and cooperate dispute means to any particular authority who decide they are ready to accept and any arbitration different themselves. Okay. Means arbitration is often used to resolution of commercial disputes means partially in the context of natural national commercial transparency means any certain countries such as the United States arbitration also frequently employed means consumer and employer matters where arbitration may be mandated by the terms of employer commercial contract. Then second, essential for voluntary arbitration means the voluntary submission of dispute to an arbitration means the subsequent attendance of witness and investigation in the enforcement of award may not be necessary means binding the voluntary arbitration may especially needed is for disputes arising under agreement and contracts. Okay. Second type, compulsory arbitration is one where the parties are required to accept the arbitration without any willingness on their part means the when one of the parties to the industrial dispute means will agree aggressive by one act of the other means it may apply to the appropriate government to refer the dispute means to any adjustment machinery means any arbitration essential for the compulsory. Then next, essential for compulsory arbitration means the countries passing through the economic crisis means industries of strategic importance are involved when parties are ill balanced means compulsory arbitration leaves no scope for a strike and lockdown is for both the parties of their very important and fundamental rights. Okay, then parts for other types of arbitration. First is ad hoc arbitration, institutional arbitration, stationary arbitration, domestic or international arbitration, and foreign arbitration. First, ad hoc arbitration means when disputes or difference arises between the parties in courses of commercial transactions. Means this arbitration is active to get justice for the balance of unsettled parts of dispute only. Second, arbitration is the main basic आहे. ओके, मी हे जे काय सांगते ते बेसिक आहे, नंतर आपण डिटेल मध्ये बघूया. Institutional arbitration, there is a prior agreement between the parties that in case of future difference or dispute arising between the parties, mean during their commercial transactions such as difference or dispute will be settled by the arbitration, means as per the clause provided in the agreement. Third is the statutory arbitration, means it is a mandatory arbitration which is imposed on the parties by operation means of law. In such case, the parties have no option as such but abide by the law land. Fourth is the domestic or international arbitration. Arbitration which occurs in India means how all the parties within India in terms of domestic arbitration, and arbitration in which any party belongs to other India means dispute is to settle in India, international arbitration. And last one is the foreign arbitration. When arbitration is proceedings are conducted in place outside India and award is required to be enforced in India, means in terms of foreign arbitration. Okay. Last, arbitration in India. One main arbitration is India Council of Arbitration 1965. Okay, means arbitration processes dispute people to group by the responsible third party. In Arbitration Council Act 1996, हे लक्षात ठेवा. Arbitration in India, India Council of Arbitration 1965, Abide Arbitration and Conciliation Act 1996, comprehensive legal framework. Okay, 95% arbitration of type ad hoc way. Okay, delay in arbitration proceeding mean interference of courts and delay in court in proceeding means India in number 2 is arbitration cases reaching Singapore and center. Okay, means interminable, complex and expensive means enforced through the court. Mumbai is to have India first international arbitration center soon. Okay, that means the Arbitration and Conciliation Act 1996. नेक्स्ट आपण थोडं हे बघूया मीनिंग आणि हे नंतर त्याचे व्हिडिओ दाखवते म्हणजे ऍक्च्युअली काय तुम्हाला ते कळेल. Main concept arbitration. Arbitration is means of securing an award on complex issues by referring to third party. It is process in which dispute is submitted to an impartial outsider who makes a decision which is usually binding on both the parties. Okay. Means in their limit right of trial to arbitration award means arbitration is not the same judicial proceeding means although in same court processing in somewhere to arbitration. Okay, means the alternative dispute resolution ADR is always to resolve disputes means outside the judicial court and dispute will be decided by one or two person. Mean arbitration and arbiter which render the arbitration award. Means the decision arbiter decision is the award legally binding and both sides in enforceable in the court. Means the parties to put in arbitration process decision on non-binding. Means it is a process where there is a determination of causes between parties in sorry. Because hearing and determination of cause between parties in controversy by the person or a person on chosen by them, means or appointed under a statutory provision. The parties submitted their dispute, means issues, and bound by award of arbitrator in relation to the matter between dispute between them. Okay. Then basic of arbitration. मगाशी बघितलं arbitrator enforce his own point of view, means on conducting parties, and the opinion of parties are not given any denomination. Means arbitration is judicial process. Okay. Then the award of the arbitrator is binding race, means equity and justice, that is there is no scope for the compromise. The arbitration is the best suited for the settlement of the contractual rights, whereas mediation is suited to the adjustment of disputes for interested. Okay. Then advantages, आता बघितलं advantages of arbitration हे detail मध्ये. Since it is established by the parties themselves, means arbitration has the particular advantages. Advantages mean the bring the dispute settlement, mean proceed down to the level of the parties. Mean the dispute workers and management tend to the have greater scope for the settlement machinery, which is effect their own. Then since arbitration is established by agreement, is more flexible than the procedures can be adjusted to the view, is that the experience of the parties and the circumstance obtaining in the undertaking or industry. First procedure for the arbitration, this procedure operating at the level to this. Okay. And then advantages of enable arbitration to acquiring to much greater familiar with the characters of the particular industry, undertaking the most code of tribunals. Means the procedure relating the expenditure when the compared to that the ordinary court in labor tribunals is cut down and delay and the result in the prompt settlement of the difference. Third is it is the informal in character, because the disputes are handled by the parties themselves, often without resource to lawyers, and arbitration therefore is less expensive than the other procedures. Then awards are capable for implementation upon arbitration, meaning scope, type, procedure. What are the arbitration agreements, international commercial agreements कुठले आहेत, arbitration कुठले आहेत, alternate disputes arbitration, okay, system ते बघतोय आपण. ओके. दुसऱ्या ज्यात फॉरेन असो स्टेट मध्ये असो ते arbitration कसं हे करू शकतो ते आपण तुम्हाला एक 10 मिनिट व्हिडिओ दाखवेन, म्हणजे तुम्हाला क्लिअर होऊन जाईल. ओके. Population, because the suitable and complying is far better than the costly work, means stoppage even though not only satisfactory from either party's point of view. Okay. Main focus types of arbitration. मगाशी बघितलं compulsory and voluntary arbitration. Voluntary arbitration implies that the two contending parties means unable to compose their difference by themselves or with the help of the mediator or conciliator, means agree to submit the conflict and dispute to impartial authority, means whose decision they are ready to accept. Means any other words under the voluntary arbitration, parties to the dispute can do themselves, means therefore voluntary are in dispute arbitration, therefore for adjustment. Okay. Essential of voluntary submission of dispute to the arbitrator, the subsequent attendance of witness and investigation. Okay. Voluntary arbitration may be specially needed for disputes arising under agreement and contracts. For the enforcement of any awards may not be necessary, means binding, because there is no compulsion, but generally the acceptance of arbitration implies the acceptance of its awards, be it for favorable or unfavorable. Okay, the essential for arbitration. Second type, compulsory arbitration. Compulsory is the one where the parties are required to accept the arbitration. without any willingness or their part. When one of the parties to an industrial dispute means feel aggressive by an act of the other, means it may apply to the appropriate government to be refer the dispute and adjacent machinery. Means that refers of dispute is known as a compulsory. Means the dispute is the involuntary refer because the reference in such a circumstance does not depend on the, so it will both the contending parties or any party to the dispute, means any entering the any party dispute the discretion of appropriate government based on the portions of existing dispute or on appraisals on that industrial dispute emerging in a particular establishment. Okay. Then essential of compulsory arbitration. The parties of fail to arrive at the settlement by the voluntary method, means when there is a national emergency which requires that the wheels of the production should not be observed by frequent work stopping, means the country is passing through the grave economic crisis. Means there is a grave public dissatisfaction with the existing industry relation, means or the industries of strategic importance or the are involved. Okay. Then industries of strategic importance are involved. The parties are ill balanced, and that is where the union or weak, means organized and powerless, and of production are not the hand of captions, means who are well organized and powerful, means any public interest and the working conditions how to safeguard, means regulated by the state, and compulsory arbitration leaves on no scope for the strikes, means any lockouts, and it deprives both the parties of the very important for the fundamental right. Okay. Then next, refer of dispute to arbitration under Industrial Dispute Act 1947. Okay, main act for the industrial disputes for arbitration 1947. Dispute method refers to arbitration under the following condition. First is an industrial dispute exists on its apprehended in the establishment, in the employer and the workers agree in writing to refer the dispute to arbitration. The arbitration agreement is the prescribed form, means signed by the parties to its the prescribed manner, means the agreement must be accompanied by the consent in writing of the arbitrator of arbitration. Okay. Then the dispute must be referred to arbitration, means any time before it has been referred to a labor court or tribunal or national tribunal. Means any refer must be a person or the person specific in the arbitration agreement to act in arbitration. Okay. Means any agreement of the arbitration must set forth, means issues and issues decided by the arbitration procedure, and any copy of the agreement is forwarded, means to government and the consulation office. Okay. First, procedure for the investigation. After the disputes has been referred to the arbitration, we will hear to the parties. First, hearing involve mastery of the facts of particular dispute as well as the relevant procedure of the collective agreement, means of the parties practices of the parties in relation to matters, means relevant to the dispute. Means any investigation of the facts and circumference of the disputes is the great important. Means arbitrator may call witness, get evidence and the relevant records and documents, means bearing on the cases. Means any arbitration decision may order arbitration in a similar cases that may suggest a line of reasoning. May when important the witness unable to attend so affidavit is often used. Okay. Then after the collection of facts and supporting materials, agreements take place. The certain principles are followed by an arbitrator. Means while dealing with a particular dispute, namely first is fair hearing, and fair hearing which demands that an opportunity should be given to both parties, means to be heard and cross exam Second, principle of natural justice. This requires that party should go to notice of proceedings and it must know what are the issue, know what parties it has to play. Okay. Then party should be free to give any evidence. Okay, means which relevant to the inquiry and which relies for the agreement. The evidence used by one party should take into the precedence of the other party. Means so that the other party may review its counter evidence. Means if necessary. Means the arbitrator should not relay any documents which is not shown and explained to the other party. And, which reply has no has the he has to completely important without any basic precedent against anybody. Okay. Last, submission of award means arbitrator after investigation the dispute has to submit his award to the government and the award will have the same legal force and judgment of the legal court of the tribunal. Means award must be signed by the arbitrator. While writing his award and the arbitrator has the issue that the first the award is in line with the terms of reference and that it does not go behind its jurisdiction. Means it must be precise the defined that is the must be clear. Means unbiased and without any vagueness that it's not in any way means capable of being misunderstood or misstep. It should be capable of being implement means in other words it should not contain directives or provision which apparently seem possible of enforcement. Okay, then the award should contain a date or specific period for its implementation. Means the award should not voluntary any provision of any law or settlement legally award at one which is binding or parties. Means the award should contain sufficient justification or reason for the settlement by the arbitration. Okay. Last part is the evidence of the compulsory arbitration. Means the compulsory arbitration promotes the prolonged industrial disputes. Means compulsory arbitration undermines the self-government in industry. That is the hampers the development of industry demography. Means it takes away from the employers and union the responsibility of working out means their mutual problems and transfer it the government created tribunals. Okay. First, it kills collective bargaining and replace with litigation. It allows the parties to avoid unpleasant confrontation of their difficulties, creating a dependency upon public authority. By requiring even an year of compulsory labor, it subject workers to involuntary service. Means any exposes workers to arbitration, means there is some penalties and before trial and correction. Okay. Uh, Only arbitration agreements, scope, type, meaning, and what are the international commercial disputes for the arbitration. Okay, आता आपण व्हिडिओ बघूया आर्बिट्रेशनचे. हा, 10 मिनिटाचे व्हिडिओ आहेत मेन त्यातले बघा. अल्टरनेट डिस्प्यूट ऑफ आर्बिट्रेशन.
Agree to have it arbitrated. Is a arbitration, much like mediation or negotiation, is a method of alternative dispute resolution, which goes by the acronym ADR. ADR methods represent alternatives to traditional litigation. Thus, instead of a case being tried in state or federal court, parties agree to have it arbitrated. To better understand how arbitration works, we need to compare arbitration to litigation and the other ADR methods. First, we'll begin with a negotiation. A negotiation is generally informal and involves a series of offers and counteroffers between the parties until they reach an agreement to resolve their dispute. It is by definition a voluntary process, and it may or may not ultimately resolve the dispute. A mediation is typically a voluntary process, though it can be required by a court. In a mediation, a third person, referred to as the mediator, tries to assist the parties in resolving their dispute. Oftentimes, a trial court judge will even order the parties to undertake mediation. The mediator's role is to help the parties reach an agreement and thus to resolve the case. The mediator can suggest the terms under which the parties should settle the case. However, the mediator lacks the authority to require the parties to settle their dispute or to dictate terms. Litigation is a lawsuit, which could result in the case being settled by motion or by trial, with or without a jury. The United States Constitution guarantees a right to trial by jury in many civil cases at the demand of either party. Should a jury make a bad decision, the trial court judge has an obligation to correct the jury's verdict. This could result in the jury's verdict being dismissed, reduced, or even increased. If the trial court judge fails to correctly apply the law, an appeal can be filed. Now we'll approach arbitration, which is an alternative to these three methods of settling a dispute. Unlike mediations or negotiations, arbitrations are binding on the parties. They are binding in at least two ways. First, the arbitrator's ruling resolves the dispute, even if one or both parties do not agree with it. Second, an arbitrator's ruling will likely prevent any meaningful appeal or modification by a trial or appellate court. Arbitrations can run the whole gamut of dispute resolution. For example, they can resolve disputes between two large sophisticated businesses, two or more insurance companies, a dispute between a large corporation and a consumer, and even disputes between two or more individuals. Under federal law, arbitration is both permitted and even encouraged, as evidenced by the Federal Arbitration Act. Under this law, disputing parties agree to waive their rights to a trial. This is commonly done before the parties even realize that there is a dispute. Such an agreement is referred to as a pre-dispute arbitration agreement. These are common in contracts that are negotiated and signed at the outset of a business relationship. Examples of such agreements can be found in mortgages and in contracts for credit cards, cable television, or even that cell phone that you're using. It's almost impossible to buy a new automobile or have a loved one admitted to a nursing home without signing an agreement that contains an arbitration clause. If an authorized individual signed the agreement, it is most likely binding. Arbitration can avoid the time and expense associated with litigating a dispute. Instead, one person or a panel reaches the conclusion in the case. The arbitrator acts as a substitute for the trial court judge, the jury, and even the appellate court. The arbitrator's decision is final, and it is unlikely to be reversed or modified on appeal. Sometimes a three-arbitrator panel judges a case. One popular method of appointment is having each party select one of the arbitrators. The two arbitrators then select the third arbitrator. Unless there is an agreement to the contrary, a unanimous decision by the arbitration panel is not required. A majority vote is sufficient. Virtually all arbitration agreements identify a forum. This is the organization that established the parameters of the arbitration, such as who can serve as an arbitrator, who is responsible for paying for the arbitration, limitations on discovery, and whether the parties can request an evidentiary hearing. One of the most common arbitral forums is the American Arbitration Association. The arbitral forum will typically have a list of approved neutrals. These are the people who are permitted by the forum to serve as arbitrators. An arbitrator may agree to arbitrate a dispute for a set fee, although arbitrators typically charge by the hour for their time. Most approved arbitrators are either retired judges or experienced attorneys. However, some organizations, such as the Better Business Bureau, prefer local professionals who are familiar with a subject matter, such as a structural engineer, for a dispute involving the construction of a house. Unless otherwise specified in the arbitration agreement, or the arbitral forum's rules, it typically is understood that the resulting cost of the arbitration will be split equally between the parties. However, many arbitration agreements require that the party who is seeking to enforce the agreement pay for the cost of the arbitration. The scope of discovery is more limited in an arbitration proceeding than in a civil action. If the matter was litigated, it is likely that the applicable rules of civil procedure would govern the various forms of discovery available, including interrogatories, requests for production of documents, depositions, and subpoenas to compel individuals to either testify or produce documents. Instead, the arbitrator will follow the rules of the arbitral forum. The arbitral forum will have rules that address the number of depositions that can be taken, the number of document requests that can be made, and the number of interrogatories that can be propounded. It can also specify the number of witnesses who can testify at the hearing. Some arbitration proceedings are simply a matter of the parties submitting position statements and supporting documents to the arbitrator, who then reviews them and issues a ruling or decision. This is common in disputes between insurance companies, in which they are each trying to determine which of their insureds caused a wreck. Other arbitration proceedings result in hearings before the arbitrators or arbitration panels. The procedures established by the arbitral forum will dictate what is permitted into evidence, how long the hearing can last, and whether the parties will be permitted to make opening statements or closing arguments. The arbitrators are the triers of fact, as there are no juries in arbitration proceedings. The authority of the arbitrator to issue subpoenas to require people to attend the hearing, or for third parties or for entities or individuals not parties to the dispute to produce documents, is also quite limited. Though its costs may pale in comparison to lawsuits, arbitration can be a very expensive method of ADR. In addition to each arbitrator charging for his or her time, arbitration forum will charge various administrative fees. Oftentimes, the fees are based on the amount in dispute and the number of parties to the arbitration. An arbitrator typically has no authority to enforce his or her decision. Therefore, it may be necessary for the prevailing party to file a lawsuit to enforce the arbitrator's award. If the arbitration took place because one of the parties to a pending lawsuit filed a motion to compel arbitration that a trial court granted, the prevailing party to the arbitration can simply file a motion with the trial court to enforce the arbitration decision. Otherwise, a separate lawsuit to get a judgment to enforce an award will be necessary. As previously addressed, rarely is an arbitrator's decision ever vacated or overturned by a court. This is true even if the arbitrator incorrectly interpreted the facts or misapplied the applicable substantive law. An arbitration can be a faster and more cost-effective method of dispute resolution. It has its shortcomings, but as this presentation demonstrates, it has also numerous practical advantages over other types of ADR and even litigation.
Arbitrations, but they don't have a clear understanding of what arbitrations are about, how are arbitrations scheduled, are they even relevant to everyday people. A lot of people have this misunderstanding that arbitrations are something to do with large commercial entities, which is not correct. And so today's lecture is going to provide a fundamental understanding of arbitrations, and then the next lecture will explain why arbitrations are hugely important for everyday people with respect to consumer contracts. Please note that this lecture is not legal advice. All of the opinions in this lecture are my personal opinions, and you don't need to agree with them. And if you have any specific questions regarding your own issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. Today we'll talk about what is an arbitration, what are some of the advantages and disadvantages of arbitration, and we'll talk briefly about different kinds of arbitration agreements. So arbitration is essentially an alternative dispute resolution process, and the courts have very minimal role in arbitration. So alternative dispute resolution, as the name implies, is a process which is alternative to our regular judicial system. So disputes in our system, legal disputes in our country, are usually resolved by courts and tribunals. That is sort of our judicial system. But then there are processes that are alternative to that traditional approach of resolving disputes, which is called alternative dispute resolution. Arbitration is one of those processes. Mediation is another process that you can have. It is important to understand that arbitration is not a court process. It is a process that is outside of the court, and it is arranged by the parties to a dispute. And what parties do is that parties agree to hire a neutral decision maker, which is called an arbitrator. Most of the arbitrators in Canada are either senior lawyers or retired judges who are hired by parties as arbitrators to hear their dispute and provide their decision. So arbitrator listens to the case, listens to the evidence, and then decides a case, and then that decision is called an arbitral award, which is like a judgment, and that decision is binding on parties. As I mentioned earlier, the courts have very limited role in arbitration. So arbitral awards are usually final awards. Most of the arbitration agreements will indicate that whatever the arbitrator's decision is, that is final, and parties have no right to appeal. They cannot go to court and appeal that decision. They cannot ask the court to judicially review that decision. In most of the cases, that is how arbitration agreements are laid out. Now, once an arbitrator has issued the award, in order, if a party needs to enforce that award, they can enforce it like a court judgment. So they have to file that award with the court, and then that becomes a judgment, and they can go and enforce it. And all of these things of arbitration that happen are based upon Arbitration Act, which is a legislation in Ontario that governs how arbitrations are dealt with in Ontario. Let's talk about some of the advantages and disadvantages of an arbitration process. The biggest advantage of an arbitration is the speed with which an arbitration can be conducted. If you go to court, if you start a court action, you have to file your claim, the other party files a defense, then you have to go through examinations for discovery and certain motions and stuff, and it may take parties 2 years or longer to get to trial and have their dispute resolved. If they choose to go to arbitration, they could have an arbitration scheduled as quickly as in 2 months' time or even faster, depending upon the issues that are in dispute. So speed is one of the biggest advantage of an arbitration process, that you can get your issues resolved very, very quickly. The second advantage is that parties have huge control over the process of arbitration. Arbitration is not run under the rules of civil procedure, and so parties can decide, mutually agree on what process they want to adopt with respect to that arbitration. Also, because the arbitration is not bound by the rules of civil procedure, the process of arbitration is quite informal with respect to the acceptance of evidence and hearing of evidence in an arbitration process. Also, arbitrations are oftentimes private. Actually, most of the arbitrations are private and confidential. So whatever the dispute is, it is not open to public, and the decisions, the awards, are not provided to public. Some people argue that arbitrations have lower cost. I highly doubt it. I believe that is not correct. In my view, in majority of the cases, the arbitration will be more expensive than the court process. Remember that in arbitration process, the parties are paying the cost of the arbitrator. A decent arbitrator in Ontario may cost you anywhere from $5,000 to $10,000 or more per day. And so what people argue is that the overall cost of the arbitration is less because you may not need to go through examinations for discovery, and you can control the number of days that you have to go for a hearing and whatnot. But in my personal view, I believe that the majority of the arbitrations will in the end be more expensive, more costly with respect to a court process. Disadvantages, as in my view, cost is a bigger disadvantage for an arbitration process because you're not relying on the public resources, the court system, to have that dispute resolved. Another disadvantage of arbitration is that there is no right to appeal. In some cases, it's a good thing, but in most cases, it takes away the right for a party to have that decision reviewed by a higher court. There is a lack of formal discovery process, which in some cases is a disadvantage. Also, there is bit of more lack of transparency in arbitration process. The courts, the judges are required to provide reasons for why they have arrived at certain conclusions. In arbitrators' case, that is not true in all of the cases. Many of the interim decisions that the arbitrator may make may not be supported with reasons, and so there is relatively less transparency in arbitration process. Costs are higher, as I've said, but the biggest issue with arbitration, in my view, with respect to consumer issues, is the access to justice. The lack of access to justice in arbitration, in my view, is a huge problem with respect to the consumer issues, which we'll talk about in the next lecture. Let's talk about arbitration agreement. And by arbitration agreement, what I mean is, how do parties get to an arbitration? How do parties end up in arbitration as opposed to a court? And there are two ways that parties end up in an arbitration. I've said the first option is the post-dispute arbitration, which essentially means that parties have a dispute, they realize that they have a dispute, and now they have a choice to make whether to go to court or tribunal, depending upon the dispute, or to hire an arbitrator and go through the arbitration process. So post-dispute means that the decision to go to arbitration is more of a voluntary decision. Parties look at the pros and cons of different options of dispute resolution, and then they decide mutually that the best approach for them is to go to an arbitration. They want the speedy resolution. They want to get the decision made quickly in a matter of months so they can get on with their businesses as usual. The other one is called the pre-dispute arbitration, which is sort of a mandatory process. And so pre-dispute arbitration essentially is that parties have already agreed to a contract in which they have agreed that if there is going to be a dispute between the parties, the only way they are going to resolve that dispute is by going to an arbitration, and they cannot go to a court. So that is sort of a mandatory agreement to go to arbitration even before any dispute has arisen. Now, the most problematic example of mandatory arbitration agreements is in consumer contracts. And a lot of people don't realize that in a lot of their consumer contracts, they are already bound by mandatory arbitration agreements, which means that if they have a dispute with that provider on the other side, they cannot go to court. The only option they have is go to an arbitrator. So, for example, home developers. In most of the cases, whether you're buying a house from Mattamy or another developer by purchasing a new house, in the agreement of purchase and sale, there is, in 99% of the cases that I know, there is an arbitration agreement clause that basically says that you, the buyer, you, the purchaser, if you have any issues with the developer, you cannot go to court. You have to hire an arbitrator, pay the cost of the arbitrator, and have that dispute resolved. If you buy stuff from Amazon, which we all do, if we have a dispute, we cannot go to court. In Amazon, there are certain circumstances in which you can go to small claims court, but you have to go to the arbitral process. You have to hire an arbitrator and have your disputes resolved. I briefly looked at the Amazon's arbitration agreement, and I believe that in small claims matters you can still go to court, and also you don't need to pay the cost of the arbitrator unless the arbitrator finds that the issue that you have raised was frivolous. So there are certain good things in that agreement too. Also, if you purchase stuff like online games and stuff like that, you will find, if you read the fine print of the contract, it will say that all of the disputes are subject to arbitration. A lot of employment contracts that I see have this arbitration clause that employees will not be able to go to court and have their matter resolved in a court process. They will have to go through the arbitration process. Therefore, it is important for everyday people.
जस्ट व्हिडिओ दाखवले तुम्हाला समजण्यासाठी. आपण नेक्स्ट लेक्चरला ॲग्रीमेंट्स वगैरे बघूया, इंटरनॅशनल क्लेम्स वगैरे बघूया. आर्बिट्रेशन तुम्ही पण सर्च करा, आर्बिट्रेशन डिस्पोज एडीआर. स्टॉप करूया. तर चॅट बॉक्स मध्ये नंबर टाका. प्रोजेक्ट आणि आहे प्रोजेक्ट सगळ्यांनी प्लीज लवकरात लवकर संपवा. 30 तारखेपर्यंत फायनल प्रेझेंटेशन असेल. 30 तारखेपर्यंत सगळ्यांनी पूर्ण कंपल्सरी थिसिस कंप्लीट करा प्रोजेक्टचा. तर स्टॉप करूया. रोल नंबर टाका आणि लेफ्ट